What we do today is to look at the provisions of the Indian Contract Act dealing with offer and acceptance. We also see how a contract is formed, different ways in which it is formed. What is the true purpose of the offer acceptance analysis? I will take you through some provisions of the Contract Act relating to them to the extent they are of the practical perspective. And while dealing with them, I will probably give some examples. And then I will take you to Carbolic Smoke Ball Company's case, which I think is a very interesting case relating to offer and acceptance. And we will also see how the offer and acceptance analysis is chosen in certain contracts as the mode of making the contract. So this is going to be the content of today's session. Offer and acceptance under the Contract Act makes us feel that offer and acceptance is the only mode of making contracts under Indian law. If we ask a question, how do you make a contract? And the usual answer is, well, there's an offer and there's an acceptance. I wouldn't agree to it fully. Why is that so? Let us suppose you and I sit and write down the points and we sign them. We have agreed. And because we have agreed and we intend that it will be enforced, we have made a contract. Neither of us has made an offer or an acceptance. Unless, of course, we say that when I suggest one clause, I am asking you, shall we put this clause? And then you say, no, no, let us take out one word from it. Then I say, well, yes, I will take out that word. Then we go to clause number 2 and I say, this is the clause I propose. And as if you are saying, yes, this is fine. Actually, we don't go through that routine. It so happens that in many cases, instances of transactions, parties have agreed and they understand that they have agreed. So very quickly, what are the different ways in which a contract is formed? And we put it into the practical perspective by asking this question, that if a question arises before a court about breach of contract, and the court has to find out where is the contract, where is this contract located so that its terms can be found. So you are arguing the matter in a court and you say, Your Honor, this is the contract. It is on page 5 or page 15 of the brief. It is a document number 75. And then you have this written document. And that document is understood to be an agreement between the parties and therefore a contract. So parties understand that they have an agreement. They are agreed about everything that is stated. And that is what makes it a contract. Therefore, we start by saying that a contract is an agreement. It may be very formal, that is in the form of an instrument, where all the terms and conditions between the parties are incorporated on the document and parties have signed it. This is what we call an instrument. You may call it a document which contains the contract. And I call it formal. There is no degree of formality in the sense to say that if it contains this, it is formal. What we mean by formal is that all the terms or the major terms are negotiated, they are written down, and they are quite sufficiently in detail, very often made by lawyers, and naturally they also made on a stamp paper. This is formality. They may also be in the form of minutes of meetings. Until they are signed, they remain unsigned. And these minutes, whether signed or not, may also contain an agreement. A question will always arise in a court, are they really agreed? That's another question. But if we say, yes, they were agreed, and if parties show that they are agreed, then they are actually in the form of minutes, and they are considered to be an agreement by the court. They may also be very informal. For example, you and I, we are not lawyers. We have a transaction. We note down the points to the extent we understand them. And we do understand them because we are in the same business. And we write it and we sign it. We don't intend to go to lawyers at all. And for us, that is the agreement. What I saw earlier were actually agreements in writing, but agreements can be oral also. So many transactions, share transactions in the good old days, material that is ordered by a buyer from a seller with whom dealings have been happening for a long time. There may be just a phone call, बस 200 bags भेज दो, and the other person says, हाँ भेज देता हूँ. And this is oral. There may be problems about proving its existence, but if it is shown that parties have spoken it and they have agreed, then there is the fact that it is oral doesn't affect its enforceability. So basically, when a question arises, is there a contract? What is to be seen is, are the parties agreed upon the terms which are stated there, or are they agreed on all the terms between them such that those terms can be enforced? This is how I look at a contract. We must always remember that the whole contract law is about enforcing contracts. It is not about making contracts, it is about enforcing contracts. And in order to enforce, the court should know what is a contract. And therefore, we require a definition. And the definition given in the Contract Act is that a contract is an agreement enforceable by law. Basically, it's an agreement. So when we look at proposal and acceptance, why do we need those provisions in the Contract Act? First of all, if you and I are in the court about a contract dispute, and you say there is a contract, and I say no, there isn't any contract, then the court should be able to locate whether there is a contract or not. And in such cases, the offer acceptance analysis enables the court to decide whether parties have agreed upon the terms. An example later will make it clear. But a proposal and acceptance is also a mode of making a contract. So in some cases like government contracts, parties deliberately, the government deliberately selects a mode of offer and acceptance in order that the contract be made. I have used here the word proposal, right? Why the word proposal? Because our Contract Act does not use the word offer, it uses the word proposal. However, all books relating to contract law are likely to use the word offer instead of proposal. The word offer is used for an offer in the English law. Now, this is how the Indian Contract Act goes. When there's a proposal and its acceptance, there is a promise. It doesn't say there's an agreement. And every promise is an agreement. This promise, which is an agreement, need not actually go by proposal and acceptance. So if we have a written contract in which I have agreed to sell you goods on 1st of January, and you have agreed to pay me the price on 15th of January, then my promise is to deliver goods to you on 1st of January, and your promise is to pay me on the 15th of January. So my promise is an agreement because you have agreed to it. And your promise to pay is also an agreement because you have agreed to it. We have agreed. Likewise, we may agree that if tomorrow New Zealand wins, I will pay you 10,000 rupees. And if India wins, you will pay me 10,000 rupees. The match is over and New Zealand wins. Is that an agreement? The answer is yes. The question is not whether there is agreement, but whether it is enforceable. So let us suppose in my first example, I don't deliver the goods to you. Can you enforce our agreement? And in the second example, I don't pay you, even though you have won the bet. Can you enforce it? We all know that the first one is an agreement which can be enforceable, and therefore it is a contract. However, the other one is an agreement, we call it a wagering agreement, but it cannot be enforced. So it is not a contract. So let us go back. In order to be enforceable, therefore, there are 4 conditions in the Contract Act and perhaps other conditions in other laws. So very quickly I will mention them because that is not the subject of our discussion. In order to be enforceable, the parties to the agreement must be competent, which is above 18. We must remember that this requirement of 21 years if there's a guardian has been taken away now. So today, everyone has contractual capacity at 18. The second is that the consent must be free. The third is that there should be a consideration, there should be lawful consideration and a lawful object. And the fourth is that the agreement should not have been declared void by the act or by any other law. And in most commercial transactions, all these requirements are automatically fulfilled. No one actually puts a tick mark in those boxes as to whether these 4 conditions are fulfilled. The fifth requirement is about formalities. Should it be in writing? Should it be in form, in a particular form? Should it be attested? That is, should it have witnesses? Should it be registered? The Contract Act doesn't require any of those things. In fact, the Contract Act simply says if the agreement is enforceable, it's a contract. And Section 10, I've mentioned the number 10 in bracket. Section 10 says all agreements are contract if the parties are competent, etc., etc. But the Contract Act in the later part of section says that if there is any other law which requires writing or any other law which requires attestation, that is witnesses, or the law requires a particular mandatory form, or any other law requires registration, then of course, without that formality, it cannot be enforced. So it must fulfill the requirements of that law. So this is about contracts and a background about formation. So now let us see what is a proposal. It is very important to read this definition. When one person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that other to such act or abstinence, he is said to make a proposal. So now if I ask you, will you buy my car for 50,000 rupees? Then I am showing you my willingness to sell you a car for 50,000 rupees. And I am asking that to you so that you will give your assent. You will say yes to what? To my selling you the car for 50,000 rupees. So this is where I am indicating that I will do something to which you will say yes. And when you say yes, then the fact that I will do something becomes a promise. Can you enforce it? You will be able to enforce it only if there is consideration, which means you have also promised me something. This is how the formation requirement operates. So we'll come back to the definition, but understand that this word, right, it has highlighted, means signifies what? That I am willing to do something, which if you say yes, I will. Okay. And why is it done? It is not done to obtain information, to obtain advice, but it is done with a view to get a yes. So if that is the type of correspondence, then naturally statement will be a proposal. And to give you an example, if I say, will you buy my car for 50,000 rupees? Well, I'm saying that so that you will say yes. Instead of that, if I say, well, see, I want to sell my car and I've been advised that I should ask for 50,000 rupees. What do you say? If this is what I ask you or I write to you, I am not asking your willingness, I am asking your advice. Or I say, look, I want to sell my car for 50,000. If you want, you let me know. Now, this can be a proposal or it can be an invitation to offer. What I mean is that where a statement is made, where a person indicates that he will do something in the commercial context, for example, does it amount to proposal or not is a matter of interpreting those words. Sometimes the court may say, oh, this is not an offer, this is just an invitation. At another time, the court may say, oh, this is not an offer, it is a mere statement. How can you say yes and consider the person binding? We'll see one or two examples. So this part is very important. I am trying to analyze all the requirements of offer with reference to this definition. And signifies indicates the communication. It is to be stated. You don't keep it in your mind. You have to indicate it. That is the meaning of the word signifies. So let us look at what are not offers. I go back here with a view to obtain the assent to the act or abstinence, with a view to obtain the yes. If that is the tenor of that statement, then it is a proposal. So what is not a proposal? Invitation to offer, right? Where a tender is submitted, we call it an invitation to offer. Invitation to offers are not proposals. They invite proposals. So if a person writes like this, that we have a lot means a collection of goods consisting of 2 lakh articles to sell as scrap. We expect rupees 10 lakh as price. Please state your offer. So they are indicating that this is what they have, and then say you make the offer. So you may make the offer for 9 lakh rupees as price, and we might say yes. Or you might make an offer that of these 2 lakhs, I will buy 1 lakh rupees, but I will pay you 6 lakh rupees as price. So you make the offer. So what this sentence does is to invite an offer. Okay. So this is not an offer. Now, if the other party answers to this yes, is there a contract? Not likely, because this is not an offer. So this yes doesn't convert it to a contract. Let us take this example of an English case often used to indicate that an offer should actually express willingness to get assent. Harvey versus Pacey is the case where Bumper Hall Pen, which is indicated here, by the way, Bumper Hall Pen is the name of an estate. So there's a person interested in buying that estate. So he writes to the representative of the owner, will you sell us Bumper Hall Pen? Telegraph lowest cash price. Answer will be paid. I don't know. Some of you who belong to an earlier generation know that people used to send telegrams for instantaneous communication. And it was indeed extremely costly to send telegrams. So the person says, look, you telegraph the price, I will pay for it. So he's put his sentence into will you sell and telegraph lowest cash price. The representative answers that the lowest price for Bumper Hall Pen is 900 pounds. So the buyer or the person who is interested, he says, we agree to buy Bumper Hall Pen for the sum of 900 pounds asked by you. Please send us your title deed in order that we may get early possession. No title investigation, nothing. They say, tell us, send us your title deed and we will take possession. Please remember that in England, the formality of registration of deeds did not exist. So you handed over the property and you handed over the title deeds. And the question was, is this a contract? Because the seller or the representative or the owner did not sell and the purchaser claimed that land. And the question was, does this correspondence amount to a contract? Because if it's not a contract, then the representative or the owner is not bound to sell. And the analysis was that, well, this may be an offer, or this is an invitation to offer. So the question is this an offer? And the analysis was that this is a mere statement because it is an answer to the second part. This cannot be called an offer, nor can it be called an acceptance, but this is a mere statement. If we analyze it in terms of the Contract Act, it doesn't express the willingness to sell, number one. And if we go to the definition of acceptance, it doesn't express the assent that yes, I will sell. So you will notice that the whole case rests upon the interpretation of these words in the telegraph, the contents of the telegram, and whether this is an offer or not. Likewise, in when we are transacting or when parties or our clients are transacting, somebody wants to do business and wants to make a proposal, one has to be very careful about language. So if one doesn't want to make a direct proposal, then he should say, I am inviting your offer, clear language. And if it is going to be a proposal, he should say, this is our proposal. Otherwise, it remains to be interpreted by the court in case of a dispute. Now, this offer must be communicated. Means it must be made known to the person. This is, of course, it is assumed, because how can there be an acceptance unless it is communicated? As I said, that these issues arise after a case has arisen. So there is this case of Lalman Shukla versus Gauri Dutt. A person has lost his nephew and he has a clerk, Mukadam, and he sends this clerk to search for the boy. Naturally, the man goes out to search for the boy because that is his duty. The master has ordered. Then this master, that is the uncle, he distributes leaflets offering a prize for anyone who will bring the boy. Now the employee brings the boy. He comes to know about the prize and he claims that amount. This case is not easily available. Very old textbooks in contract law, not textbook, case books in contract law will give it. It appears that after a while, this employee was removed from service and it is thereafter that he claimed the money. That may have prejudiced the mind of the judge. The correspondence or the reactions between the parties, interaction between the parties, that may have affected the way the judgment came. But the court held that this employee had never heard of the proposal, so his bringing the boy cannot be an acceptance. For example, if the uncle had distributed the leaflet, you had obtained that leaflet or the pamphlet, and based on that, you went out in search of the boy, and you came back with the boy and the pamphlet and you claimed the prize. Then you say that, look, I read this offer and therefore you give me the money. Because that will be a contract. And when there is a contract, there is an obligation to perform what is promised. But the court held that here is a person to whom the proposal is not communicated. And therefore, there is no question of it being a contract, and therefore no question of his getting the prize amount. Now that brings us to the question, to whom should it be communicated? Here is where I classify offers into basically two types. One is which is made to a specific person. So I am selling goods. I address it to you. Suppose your company is called XYZ company. So I say to XYZ company, here is my quotation of goods. Please place the order. This is a proposal. This is addressed to a specific person. The other example is what we find in Lalman versus Gauri Dutt, a pamphlet saying whoever brings the boy will get the amount. This is a general offer because it is not addressed to any particular person, but it is of a type which can be accepted by only one, that is one who brings the boy. So general offer capable of being accepted by only one. And there can be total general offers which more than one can accept. So anyone who fulfills the requirements of that offer will be deemed to accept that proposal. So they may be general if they are to anyone or all, general. And if they are made to a specific person, then we call it specific offer. Later on, I'm going to discuss Carlyle versus Carbolic smoke ball. This case is an example of a general offer which is capable of being accepted by anyone. And I'll come to section 8 again later. So we ask this question, when is the communication of proposal complete? When do we say that a proposal is communicated? Because we are looking at this requirement. So section 4, para 1 states that the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. So the employee in Lalman versus Gauridas, had he received information and had the advertisement come to his knowledge, then we say that yes, the proposal was communicated. So it should come to the knowledge. Now, please remember that there are other wider issues involved here. That if it's a company, when do you say that it comes to the knowledge of the company? You know, when it comes into the inward in the company, or when it goes to the specific person who is able to take the decision on it. Well, these are open questions yet to be decided. This proposal may be express, where I say, I offer you these goods at this price. Please let me know. If you want to place the order, send 50% advance. Express, stated in words. Or it may be implied. And I can think of an implied offer in this manner. You may have heard of sale of goods on sale or return basis, where in anticipation that you will buy the goods, I send you the goods. They land at your door. And on top of it is a condition that if you want to keep the goods, you keep them. Otherwise, you can return. But if you don't return the goods, then it will be considered that you have bought them and you will be liable to pay the price. Here, my sending the goods to you with the condition is implied because it is in the nature of conduct. I, of course, told you a situation where terms and conditions are attached to it. But this is just sending the goods, and when they are accepted, claiming the price. That can be an example of an implied offer. Let us come now to acceptance. The yes to the offer is the acceptance, the assent. This was the word used in proposal. That is the word used in the definition of acceptance. Section 2, clause B, defines acceptance. When the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. The person to whom the proposal is made. So that tells us who should accept. So we go to Lalman versus Gauridas. The proposal was not made to him at all. We will again see in Carlyle versus Carbolic Smoke Ball that Mrs. Carlyle, by using the smoke ball, had accepted it. So he is the person to whom the proposal is made. Let us suppose that I send a proposal to you for selling my goods and you are XYZ company. You have a sister company, which is ABC company, and you think that ABC company needs those goods. So you send my proposal to ABC company. ABC company writes to me a letter of acceptance. Is there acceptance? The answer is no. Of course, if I want to do well in my business, then I will accept what ABC has written to me. So although ABC and company says, Mrs. Bhadbhade, we accept your offer, I had not made the proposal to them. Nevertheless, I can say, yes, I will supply the goods to you. So what ABC and company has done is given me the offer, and my saying yes means I am bound to ABC company. However, if ABC company sends me an acceptance and I do nothing about it, there is no contract because ABC company is not the company with whom to whom I have made the proposal. The next part of the definition is that this acceptance must be signified, stated, communicated. And what should it communicate? The assent. So it should say yes. It shouldn't say, oh, but no. It shouldn't say, can you give me more information? It shouldn't say, thank you for your proposal, right? But it doesn't say yes to it. These are something less than the assent, and therefore there will be no acceptance. So we saw who, we saw what is meant by assent. Please note that when the person to whom the proposal is made signifies his assent, there too means to the proposal, and that it should be communicated. Therefore, built within this definition are the requirements of a valid acceptance. Now, what can the proposee do? The person to whom the proposal is made. What all can he do? He can simply keep silent, not do anything. There is no acceptance. He can suggest a change, or he may reject it. And of course, I should put on the top here, he may say yes. The yes may be formal. I hereby accept your proposal dated so and so. Or the yes may be in the form of an advance, because if the proposal says with your acceptance you send 25% advance, then sending the advance is acceptance. So the yes may come in different forms. So he can do any of these. These three are not acceptances. This is the acceptance. Now I'll speak a little bit about this, that the proposee can keep silence. Can the proposer give a proposal which says, Mr. X, if you don't inform me anything, then I will consider it as accepted. In contract law language, we say that can it be indicated that silence will amount to acceptance? And the answer is no. The proposee is entitled not to state anything. So he may keep silent, and if he does, there is no contract. This acceptance must be communicated. If it is oral, then it is communicated immediately. Even if it's on the telephone, it is communicated immediately. But where it is given in a mode which requires transmission, then we refer to what is called the postal rule. So what we are essentially saying is, and let me now use this, that on 1 January 2022, the proposal is posted from Pune, P and P. On 5 January 2022, it reaches A, that is the one who's going to accept, at Ahmedabad. The decision to accept is taken. Now, if it's a company, it may involve a resolution. On 10 January, the acceptance is posted. On 15 January, it reaches the proposer at Pune. And therefore, we ask that when is it that the acceptance is communicated? Because when it's communicated, it becomes a contract. The moment it is communicated, the contract has happened. So both the parties become bound to each other and they cannot separate. They have their obligations. If they break them, consequences will follow. The contract will get enforced. What is that moment of time? That moment is when the acceptance is communicated. So when is it communicated? Till here, it is just a decision. And if it is minutes of a meeting, and those minutes are sent or are unlawfully obtained by the proposer, there is no acceptance, because the acceptance has to be stated, signified. But communication has two parts. One is where I state my acceptance, and the other is where I send it to you. So I write down my acceptance, that is part of communication, and I send it over to you so that it can be, it will reach you. So both these constitute communication. And you will notice that this is the day the letter is posted, and this is the day that it reaches. Now, a proposal is communicated when it reaches, when it is received. But as regards acceptance, it is a converse rule. We call it the postal rule. So let us look at para 4, the second para of section 4. The communication of an acceptance is complete as against the proposer, who in our case is P, when it is put in a course of transmission to him, and that I will say when it is posted, so as to be out of the power of the acceptor. So let us go here. This is the date when it is put into a course of transmission, and when it is posted, the post office is supposed to be the agent of the addressee, that is the acceptor, and the post office is not supposed to give back that letter to P. So it has gone out of the reach of P. When it's put into that course of transmission, that is the time as against P, the acceptance is complete. Please remember, the contract has happened here, but P doesn't yet know about it. So he is bound by a contract at least until the 15th, even though he does not know about it. This anomalous rule, very peculiar rule, is referred to as the postal rule. What you observe is our section 4 does not use the word posted, it uses this, right? And therefore it will apply to telegrams. And I believe that it should apply to emails also, because when you send an email, when you click on the send button, it is not possible to take it back. And I believe, therefore, that to emails also, this will apply. So this is then the postal rule. If it happens on the telephone, then what? See, when it is put in a course of transmission, so you utter words on the phone and you can't take them back, right? They have gone. So do we apply the postal rule to this? A very well-known case which you must read is Bhagwan Das versus Gidharlal, decided by the Supreme Court, where the Supreme Court applied the oral rule to communication on the telephone. So it has to be received. Postal rule, it has to be put into the course of transmission. Wow, what was the issue in Bhagwan Das's case? I mean, I forget where the proposer was, but let us say that I have uttered the words of acceptance from Pune and you are at Delhi. So when I utter the words at Pune, is the contract made at Pune or is the contract made at Delhi? We must remember that this is the rule which tells us where the contract is made. So in this case, if the acceptance is posted at Ahmedabad, then the contract is made at Ahmedabad because that is where the contract happens. In Bhagwan Das's case, it was on the telephone. And the question was, do we apply this rule so that the moment I utter the acceptance on the telephone, right, it is binding on you at Delhi, and therefore Pune court will have jurisdiction. And your argument will be that postal rule doesn't apply, and therefore it has to reach you so that Delhi court will have jurisdiction, not Pune court. It was in this context that the rule was interpreted in Bhagwan Das's case. Two judges said that the postal rule doesn't apply. And one judge, Justice Hidayatullah, he used section 4 to say that you put it in the course of transmission and you can't take it back. And therefore, the Pune court, in the example I gave you, will have jurisdiction. I will again repeat to read the Bhagwan Das's case. The principles that are discussed there will be very useful when we look at acceptances by modes using current technologies. I'm talking of the principles, not the ratio. And as against the acceptor, when it comes to comes to the knowledge of the proposer, I will ignore this part. This is important, but for today's discussion, I don't consider it important. So my point is that acceptance must be communicated. Now, let us, yes, there is one more requirement. Acceptance is an acceptance if it is absolute and if it is unqualified. Absolute means whatever the proposer proposes in his proposal, everything should be accepted by the person to whom it is made. So it is absolute. when it is of all the terms of the offer. And there should be no qualification, no buts, no ifs. So where the acceptor says, thank you so much for your proposal, we are saying yes, but this is subject to approval by our board of directors. So our yes is not a clear yes. There is a qualification. Our board of directors has to approve it. This is no acceptance. So if you do not agree to everything, that is not an acceptance. And if you put a condition saying this will be subject to our lawyer's approval, subject to the board's approval, it will be subject to contract, then naturally it is not an acceptance. Of course, please remember that the words used in acceptances, like subject to contract, it's a matter of interpretation based on all facts of the case. Plenty of judgments of the Supreme Court deciding either way. So either saying that no acceptance till a formal contract is signed, or it says, well, formal contract is just a formality. This acceptance is good enough. Do read those judgments. I will not be able to discuss them in whatever time we have today. Very quickly. There is a quotation by S, who is the proposer, that I have 5,000 pieces. I will sell them at 1,500 per item. The delivery will be at your place within 15 days. This is the price, 25% advance, 50% on delivery, 25% 15 days after delivery. And Pune courts will have jurisdiction. The proposee gives no reply. There is no contract. Let us look at the second one. The same quotation, right? I've just added this 15% interest. What does the proposee say, the purchaser? He says yes. And he says, I will buy it at 1350. And he, on the basis of 1350 per item, whatever is 25%, he makes out a check and he sends it. Is there a contract? No. What the proposee has done is that he has made his own proposal, that I will buy this at 1350 per item. Will you sell me? So this becomes a counter offer or a counter proposal. Now let us suppose that in this example, when this check is received, the seller deposits the check. This depositing the check shows that the counter offer is accepted. When this check is deposited, the seller is now bound to sell goods at 1350 per item. So we have a contract where all this is agreed, except for the price. The price will be 1350 per item. This is acceptance of the counter offer by conduct. This is the next example. There's a quotation by S. The proposee says yes, yes. He says check I give for 20%, so he attaches the check. But in the letter he says please delete this provision. Which one? Pune courts. Now remember, the essential business terms are agreed. It is only the jurisdiction. I mean, if there is a dispute, matter will go to court. Only that much is to be deleted. Here, all the terms of the proposal are not accepted, and therefore this becomes a counter offer. If S deposits the check, the counter offer is accepted. If S does not answer at all, there is no contract. If P says afterwards, this is not accepted, S doesn't answer, and then the purchaser says, okay, I agree that Pune court will have jurisdiction, and he again sends 25% advance because this check was not deposited. Is there a contract now? The answer is no, there is no contract. Why? Because here, this is just a counter offer. This counter offer is not accepted. This counter offer is not accepted. And because it is not accepted, right? Because there is silence on the counter offer, the original proposal has lapsed. It stands revoked. And therefore, this is not an acceptance, and the seller is not bound to sell the goods. We must remember that the same analysis appears when it is a case of novation, alteration, and rescission. What do I mean by that? We already have a contract in which, let us say, the price agreed is 15,000 per item. And it is my allegation that we have changed the terms and made it 16,000 per item. You say, no, that was never agreed, that was just proposed. So I say, no, we have a new contract for 16,000, or we have an altered contract for 16,000 per item. The question before the court is whether there is a new contract or whether the contract terms are altered. For the purpose of coming to the conclusion whether there's a new contract or whether the terms are altered, the offer acceptance analysis is adopted. Similarly, one party says there is no contract now because we have cancelled it. Rescission means brought to an end. And the other party says, no, no, of course it's not cancelled. It was just proposed by party. We never agreed. So has the contract been cancelled? Has it been rescinded by both parties? It has to be done by both parties. This is section 62. And what analysis is adopted? Of course, novation can happen by a formal document that our earlier contract is cancelled and this is the new contract. But when this is not done, the question whether there's a new contract or not, we apply the same proposal acceptance analysis for the new contract or for the altered terms. Now, very quickly, I will take you through Carbolic Smoke Ball Limited. Notice that the case is decided in 1892 by the Court of Appeal, and this is after our Indian Contract Act. Why I state that, you'll understand later. So, this is the advertisement. The carbolic smoke ball, it is a ball made of rubber in which carbolic acid powder is put, and you press the ball and you sniff it, something like the Vicks inhaler, right? To inhale the fumes. So it says carbolic smoke ball will positively cure so many illnesses. This is the list of illnesses. And £1,000 reward will be given to anyone who catches influenza. So here is the text version of it. These are the illnesses. And these are all caused from one cause. They can be cured by this remedy. 100 reward will be paid pounds by this company to any person who contracts the increasing epidemic influenza caused by taking cold after having used the carbolic smoke ball according to the printed directions supplied with each ball, and £1,000 is deposited with the Alliance Bank, showing our sincerity in the matter. And Mrs. Carlyle, she purchased the carbolic smoke ball. Notice this advertisement, this part here, if you can notice my cursor. These are all testimonials given by people who have used that carbolic smoke ball and who have said that it is effective. Mrs. Carlyle therefore purchased it, and she used the ball 3 times, and she caught influenza, and she filed a suit to recover £100. It's a large amount in 1892. And the company said, number one, this is not a proposal, this is an advertisement. So was it a proposal? Did it show a serious willingness to fulfill the promise? The main thing the court said is, look at this sentence. We have deposited an amount in the bank that shows the seriousness. So it's not an advertisement, but it's a serious promise made by the company. The second thing the company said is that she never accepted, she never informed us that she has accepted our proposal. She should have informed us, communicated the acceptance. All she did is buy the package and use it. And the court held that the company itself indicated that it did not need acceptance. It said, you do this, and if this is what happens, you catch influenza, then we will pay £100. So there was no need of communicating any acceptance. Please remember that this is one instance where acceptance need not be communicated. The proposal indicates the conditions, and those conditions are fulfilled. There are other issues in it, whether there is consideration or not. Please read the case. It's a very interesting case. Now, the fact that if conditions of a proposal are fulfilled, then that amounts to acceptance was decided in Carlyle versus Carbolic Smoke Ball in 1892. We already have a section 8. I have only summarized one part of it. The other part is not relevant for our discussion. What does it say? Performance of the conditions of a proposal is acceptance of the proposal. So if the proposal says send the check, and if you send the check, sending the check is acceptance, but at least the check is received. Here is a case where people were told, you just buy this, use the ball. You're using the ball, buying it and using the carbolic smoke ball. That much is enough acceptance. We have given up our requirement of acceptance. This is how it was interpreted. So, this is the interesting part. What then did the company do? Apparently, the company paid two people, Mrs. Carlyle and somebody else. And then it gave even one more advertisement where it said, we will again now give £200 reward if somebody catches influenza. Now you can imagine that so many people can make false claims that they have caught influenza. So how to get over it? So what did the company say now? Right? The carbolic smoke ball company now offer £200 reward to the person who purchases the carbolic smoke ball and afterwards contracts influenza or any disease caused by taking cold while using the smoke ball. The offer is made to those who have purchased the carbolic smoke ball since January 1, 1893. One condition. It is subject to conditions to be obtained upon an application. So you apply, right, for this to get this prize money, to get the money. Then a duplicate of the application must be signed and deposited with the company in London. Please remember the advertisement was also given in American newspapers by the applicant before commencing the treatment. Now, when you saw those applications, it also contained a condition that you must come and take the 3 doses at the company headquarters. So you come to our office, you take the 3 doses there, and then if you catch influenza, and provided you have purchased the smoke oil after this date, then we will pay you £200. And then it also said that this offer will remain open only until 31st of March. Now, why am I giving you this interesting example? Please remember that when you are drafting general offers, it is important to remember that anyone who fulfills the condition, the, the person, the proposer, is bound under contract to them. So it is likely that you give an offer, a general offer, that whoever will pay 500 rupees, we will send them this article. And it is likely that lots of people will send you the money. Their sending the money is the only condition your proposal requires, but your stocks are over and you cannot supply. You have a contract and you have broken it, correct? And in today's world, it could also be considered unfair trade practice. So, whatever are the protective elements to protect the interest of the proposer, they ought to be built within the proposal itself. When you are drafting, for example, advertisement relate like material to be posted for companies who sell on the internet, one has to be very careful about the terms and conditions that are drafted. And this is where I come to one of the oft stated requirement or feature of an offer. What is that? It says that an offer must contain all terms. An offer must contain all terms. Now, a person making the offer, he puts whatever terms he wants. What do we mean by this? That an offer must contain all terms. We mean that once the yes comes, you cannot make any changes. So, whatever you want to put in the offer, you put it now. This is offer acceptance analysis. Now I come to, and this is almost the last slide. Offer and acceptance is also a selected mode of formation of contract. So in government contracts, tenders are invited. That is a notice inviting tenders. The contractor submits the tender. That is the tender. That is the tender. And when many tenders come, one of them is to be selected and accepted. Similarly, you want insurance, you make a proposal. The company's website invites proposals. You make proposal in the form given by the company. The tenderer also submits the tender in the form given by the government. Why? Because the proposal is to be analyzed before it is accepted. Similarly, you want a bank loan, you apply for the bank loan. So the bank says, do you want a loan? Come and apply. Is this an offer that you just apply and we will give it? No, this is an invitation. And you are supposed to apply for the loan because a decision is required whether to give it or not. So this is a deliberate strategy to convert the making of the contract into an offer and acceptance. But even more than that, the offers in all these cases are made on forms which are provided by the intended acceptor. So now I could analyze it in practical aspect in this manner.
Ma'am, can you suggest me some authors and book for drafting the contract and agreement?
Are you a practitioner, lawyer?
No, ma'am. I'm a student. Actually, I'm a graduate, LLB graduate.
There is a book by Rodney Ryder, Drafting Commercial Agreements. A very good book about drafting agreements is by Tina Stark. Tina Stark is a foreign
And
book. It's pretty expensive.
any Indian authors?
Rodney Ryder.
Thank you, ma'am.
Any authority or judgment on unsigned minutes of meeting have been treated as an agreement?
There might be one, but I don't recollect. I cannot state just now. I'll have to find out whether unsigned minutes will amount to agreement. There shouldn't be any problem. Proper evidence must be given. So evidence will not just be about the unsigned. The real thing is that in the minutes discussion happened and that was agreed. So evidence about that has to be given. Oral evidence, maybe video recordings are there. It is just
Okay.
like saying you and I sat down and spoke and wrote down and had an agreement, oral agreement. And if I am enforcing it, I stand in the witness box and say, this is the oral agreement. And the other party says, no, no, we have no agreement. So it is my word against that person's word. Very usually, oral agreements might be followed by some action, like an email confirming it, an email saying these are the minutes, please confirm, right? And work has started on that. So later evidence may also support the formation of contract.
In today's scenario, where the emails have a recall feature, wherein email already sent is called back and is still in offeree's control, how could communication of acceptance rule apply? How would communication of acceptance rule will be applied?
I have not yet tried the recall feature, but where the recall feature is used, then naturally it has been put into the course of transmission, but it is not out of the power. All this therefore becomes a matter of evidence. And it's good I came to know. Let me see whether if I use Gmail, I can recall my email. I'll have to try it out.
Whether all contracts in India are governed precisely in accordance with the Indian Contract Act, and there has to be a specific date written on the contract.
Let me answer your first question. Are they all governed by the Indian Contract Act? Yes, of
Yes.
course they are. In fact, practically the whole of Indian Contract Act, other than the chapter of formation, because that tells us what is a contract. And I would say the provision of liquidated damages, which remains under court's control. All other provisions are default rules. So we first find out what is stated in the contract. And if there's nothing stated in the contract, then we apply the act. So much so that even the section relating to impossibility is a default rule, because if there's a force majeure clause, then the clause applies. There may be exclusion clauses. That is, even if there's a breach, there will be no compensation. Excluded. All claims for compensation are excluded. That also goes against the Contract Act. So basically, the Contract Act, the main provision, I believe, which is the heart of contract law, is Section 37. Section 37 says that parties to a contract must perform their respective promises. And at least to that, the Indian Contract Act applies. The Indian Contract Act applies to all contracts. However, there may be laws regulating some types of contracts, then naturally the laws affecting the contract, special laws affecting the contract will also apply. The second part is, should there be a date on the contract? The law doesn't require. We ought to put a date. What is the benefit of having a date of the contract? Well, many other provisions in the contract might be related to that date. So it says within 15 days from the contract, we will supply you this. Then naturally, we have to have a date. But if evidence of date is not given, if the date is not mentioned, it can be proved by evidence. It is still a valid contract.
Is English law different from Indian law with respect to offer and acceptance?
Is Indian law relating to offer and acceptance different? I would say no, except that in Indian law, acceptance can also be called back. It can be revoked. But English law has no such provision.
What happens if an offer is not accepted in the prescribed mode?
Our Contract Act in section 7 also talks about the manner of acceptance. To give a very simple example, if I send a proposal to you and I tell you that your acceptance will only be by a letter which is not registered, which is an ordinary letter, then you must send it likewise. If I say that your acceptance should be only by email written to this address, which may be a different address than mine, then so should your acceptance be. However, when we divide the proposal into parts and we say this is the part relating to the contract and this is the part relating to the manner in which the acceptance is sent, then the provisions are different. The acceptance of the main part of the contract must be unconditional. But let us suppose that I say manner of acceptance is only by email sent to this address, and you send an email to my address from which I sent the proposal, then it is for me to consider whether I will accept that acceptance or not. And if I don't, then I should write to you immediately saying, please send it to that address. I cannot consider it. Otherwise, once I receive it and I don't take action in reasonable time, then naturally acceptance is valid. So the distinction between these two parts of the proposal is made in section 7. Yes, the question has come in chat. If I read only the exclusion part and presume that other than those in exclusion is part of performance of contract. Let me attempt to address this with as I understand it. Perhaps the exclusion part means the exclusion clause. This is what I assume. And then there is a part which is other than the exclusion. Is it part of the performance of the contract? The answer is yes. If the exclusion part which you say refers to exclusion clause, then that is not, there is no question of performance of it. That is actually resolution for non-performance. That if one party has not performed, then can the other party claim compensation? Well, the clause will indicate that it is excluded. So it is not the primary obligation under the contract. Primary obligations are to be performed.
How long is any contract valid? It is from perpetual or till any specific period has elapsed.
First of all, if we are making contracts in writing, it is a good idea to put a term. Say it's for 1 year, or I will supply goods up to this date and you will pay the price at this date. Or I will keep on supplying goods as you order and the period of our contract is 3 years. It's a good idea to put that term. Let us suppose it is not put there, it is not permanent. How much will it be depends upon the nature of goods, subject matter, the purpose for which it is made. So it would depend on the facts of each case. You cannot imply a term that when no time is agreed, then it is to be the period of the contract is permanent. Now, there is another aspect of time. If a person says that I will supply you goods and no time is stated, then is it that he can supply even after 2 years and claim the price? The answer is no. You go to section, I think, 46, which says that if no time is specified, then the promise must be performed within reasonable time. How much is reasonable depends on the facts of each case. So neither can he attempt to perform after that reasonable time is over, nor can the other party claim performance after that reasonable time is over. This is about performing promises within reasonable time. Yes.
Consideration for the contract can be fulfilled by the proposer only, or it can be fulfilled by any other person. What is the position in this regard with respect to English law and Indian law?
What is consideration? Broadly, we say it is the return for the bargain. But that is not the case. We have a very technical definition under our Contract Act. So let us suppose that I have made a promise to pay you ₹1,00,000. For what? For the price of goods which you have promised to sell me. So we have a contract. You are going to sell me goods. I'm going to pay you the price, probably fully in advance. And after that, you are going to send me the goods. So I have promised to pay you ₹1,00,000 for goods which you are going to supply. My other promise is a promise where I agree to pay you, or I promise to pay you ₹1,00,000 as a gift because you did something, you achieved something, or because you're an institution and I'm convinced that you need the money. I break both promises. Can you enforce? Please understand that the requirement of consideration is about enforcement. And what we see is whether there is consideration at the time of making of the contract. So we go to the date of making the promise. And then we ask, at the desire of the promisor, what has the promisee done? Now, the promise of paying you is my promise. So I am the promisor, you are the promisee. So if you want to enforce my promise, you have to show what have you agreed to do at my desire, or you have done. You have done, or you are doing, or you have agreed to do at my desire. Let me take the first promise. The first promise is, I promise to pay you ₹1,00,000 for the goods which you have agreed to sell me. So what are you going to do at my desire? You are going to supply me goods. When? After the money is paid, that's another matter, but you have given me a promise to supply the goods. In the other promise, what is it that you are going to do at my desire? Nothing. And so there is no consideration. So look at the technical definition. If I am enforcing your promise, I have to show what I have done or am doing or promised to do at your desire at the time of making the contract. So consideration is reckoned at the time of making the contract. After that, when I give you the money, I am performing my promise. And when you deliver the goods, you are performing your promise. There is a tendency to say that I am giving you consideration and you are giving me consideration. Well, in contract law terms, I am performing my promise and you are performing your promise. And we are performing and we can enforce because our both promises are supported by consideration. Your promise, in return for your promise, at your desire, I have agreed to pay you the money. And for my promise to pay you the money, you have agreed to supply the goods. You do not find that in the gift promise. This is consideration. Now, your question is that can consideration come from a third person? In Indian law, yes. And Chinnaya versus Ramaya is the case where there is a woman and there is a daughter and her brothers and sisters. So she gifts a property to the daughter, and the daughter makes a contract with the brothers and sisters. She promises her mother that I will pay an amount to the brothers and sisters. The brothers and sisters are claiming the amount. Of which promise? Of the promise which the daughter has given to the mother. But they can't claim under the doctrine of privity. But the daughter has again made a promise to the brothers and sisters that I will give you the money. And that is the contract which the brother is going to enforce, or the sister is going to enforce against her. So she says there's no consideration. Now, what is the promise? I will pay. Who is the promisee? The brothers and sisters. The brothers and sisters have to show that what they have done or what somebody else has done, right? What is that? Who is that somebody else? The mother. What did she do? She gifted the property. So she gifted the property to the daughter who made a promise, and that promise is being enforced. So the stranger has supplied consideration, and the stranger is the mother. Chinaya versus Ramaya, do read the judgment because that says that the English law is different.